I can see we're up to about 150 participants, so in the interest of time, we'll get going. Good morning, everyone, and welcome to today's In-House in Focus webinar. My name's Lino di Lorenzo. I'm a litigator based in our Cambridge office. Today, we're going to be talking about a very thorny topic of legal privilege issues for in-house lawyers in particular. I'm joined today by Simon Pedley. Some of you who may know Simon as a partner based in our Manchester office. He's an experienced commercial and corporate disputes lawyer. And he will be joined also by Rachel McDonnell, who's a dispute resolution lawyer based predominantly in our Norwich office. In addition to general commercial disputes, Rachel specialises in investigation work, in particular expertise in financial services and regulatory investigations, and she's going to cover privilege in the context of investigation. There's a few housekeeping bits and pieces just before we get going. This session is being recorded and we'll make the recording available to you after the session. If you have any questions, please do put those in the question and answer tab, and we'll try if we can to deal with those at the end. If you can put your name when you ask the question, and also identify what part of the talk it relates to as well. We'll do our best to answer those, but we can then follow up with you at the end. If you remain anonymous, we won't be able to do that. We should be done by about 10:45. And at the end, you'll have the opportunity to leave us with feedback. So please do that so that we can know how we get on and what you would like us to cover in future. So without any further ado, I shall hand over to Simon and Rachel.
Thank you very much, Lino. Good morning, everyone. I should say just at the outset, this is my best of my recollection. This was a talk we had intended, or an earlier version of this talk we'd intended to do in person, but I have a feeling this was the first webinar we did when the pandemic struck just over 2 years ago. So if you get a slight sense of deja vu, that may be because you remember bits of that. It has been updated, of course, with things in the meantime, and obviously today we've got Rachel talking about investigations and that side of things, which is all brand new. So I'm looking forward to that very much. So what do we hope that you will get out of today? Well, just a reminder of what privilege is, the basic types, a couple of case studies in there, if we've got time for those. As I say, Rachel's looking specifically at privilege in investigations and the particular issues that arise there. Throughout, hopefully, we'll talk about tips as to how you ensure privilege does apply within your organizations and how then to avoid losing it, which can happen very easily. And hopefully, particularly for you, to help you bring this to life for your board and your management, because that, I think, is a crucial point. I'm aware of lots of cases and situations where senior management just don't get this, and they understandably don't have an awareness of what might have to be disclosed should a dispute ever arise in the future, and they'll just go off firing WhatsApp messages to each other and texts and everything else without realizing they are creating disclosable documents, many of which may well not be privileged from disclosure, and these things can be absolute nuggets of information when it comes to a case. So hopefully we'll give you some tips as to how to ensure the senior people in your organization don't mess things up for you. And this is the thing. You only really look at privilege and pore over it when a dispute or an investigation or something arises. Prior to that, it's easy not to think about it. So if we move on to the next slide, we will look at what is it, why does it matter? Well, a couple of quotes there. Legal professional privilege protects from disclosure confidential communications and material evidencing such communications that take place between clients and or their lawyers, and in some circumstances also between clients, lawyers and third parties. One of the highest rights recognised by English law. It has existed for over 400 years and is treated under English law as a fundamental common law right and a human right. And the Law Society has said similar things. They say it's a precious right, vigorously protected by our judiciary and usually treated with the utmost respect by Parliament when it legislates. So it's a right of the client, not the lawyer, and entitles the client or its successor entitled to withhold evidence from production to a third party or to the court, written or oral evidence. So as I say, it's most often seen in the context of litigation or investigations. So if we go to the next slide, just the obvious reminder, and what we'll mainly be looking at is legal professional privilege in its two aspects, legal advice privilege and litigation privilege, which have similarities but also have some significant differences. If time permits, we will look briefly at without prejudice privilege and common interest privilege. I suspect those may go by the wayside, but just as long as you're aware of the concepts, and there are things to think about when relevant. So if we move on, then I'll look first at legal advice privilege, and Rachel's going to look at litigation privilege in a moment. And as the slide shows, and as we've mentioned already, it's about confidential communications between lawyers and their clients made for the purpose of seeking or giving legal advice. It's a substantive right, but it's got to be confidential. And as we'll talk about, it's got to be for the dominant purpose of seeking legal advice. So the privilege applies and protects the client in a vast range of situations. It applies to requests from public authorities, for let's say police or tax authorities or the CMA or whoever else it may be. They may seek documents, but if it's privileged, you don't have to disclose it unless there is very clear statutory provision to the contrary. And people don't always get that. I did a talk 2 or 3 years ago to a load of in-house charity lawyers, and one of the attendees was adamant that if the Charity Commission asks to see your sort of legal advice, you have to provide it. And I was pretty clear then, and I checked afterwards and remained pretty clear that no, you don't. It unless something in the Charities Act says it, which it doesn't. Privileged stuff is privileged stuff, and I've done this with clients before when we reply to the Commission and say, well, we're not going to show you that because it's all privilege, and they sort of huff and puff a bit and say how disappointing that is, but there's nothing they can do about it. Privileged advice is privileged advice. And there are actually very few statutory exceptions that abrogate that right to privilege. The Regulation of Investigatory Powers Act 2000 is one of the few that does. And even if a statute does permit some sort of abrogation of privilege, it's generally pretty difficult to persuade a court to construe that in a broad sense. They construe it as narrowly as possible and sort of preserve the privilege. So one of the JSC, BTA Bank and Ablyazov cases in 2012, one of these ongoing Russian oligarch litigation things, it was around a contempt of court, and the question arose there, did the solicitors have to disclose contact details for their client? And notwithstanding the particular legislation there, the judge said, actually, no, they don't, that's privilege. And there's another case, SRJ versus Persons Unknown, which was around defamatory or similar internet blogs, and a particular client had instructed his lawyer on the basis that that lawyer would keep his identity completely confidential, and the court held that that was privileged information which didn't have to be disclosed. Now, at the heart of it, it has to be confidential, of course. If there's no confidentiality, it can't be privileged. And there are certain things there is no confidentiality in. So transcripts of proceedings in open court is one. Attendance notes of meetings where both parties are present. So if you, as in-house counsel, is at a party meeting and you take a note, your note of that meeting is not privileged because it's a record of a non-confidential, non-privileged organisation. And similarly, a telephone attendance note between you and a lawyer for a different party. An exception if you sort of add notes and advice and so on into your own note, but broadly speaking, that's not a privileged document. And you've got to just be careful about what documents are covered. And one of the cases since the last time we did this was the Court of Appeal ruling in Sports Direct and the Financial Reporting Council. And the issue that arose there, a certain class of documents were privileged emails, but which had attachments to it. And Sports Direct was saying, well, no, these should be construed as just the email and its attachments, a single privileged document. We don't have to disclose it. But the conclusion of the Court of Appeal was no, if the attachment is a non-privileged pre-existing underlying document, merely attaching it to a privileged communication doesn't cloak that document with privilege, which is not unexpected actually, but Sports Direct are quite aggressive litigators. I know because I've litigated against them myself before, but they gave it a go, but the Court of Appeal said no, and the Supreme Court refused permission to appeal. So that might be as you expected. And also, again, it's relatively recent. This was also in 2020. It was confirmed for legal advice privilege. There has to be a dominant purpose for seeking legal advice. As Rachel explained, there's always been a dominant purpose test for litigation privilege, but it's true for legal advice. And that was the Civil Aviation Authority and the Queen on the application of Jet 2. And Lord Justice Hickinbottom said there, while I accept that the jurisprudence is far from straightforward and the authorities do not speak with a single clear voice, I consider that first instance judge was correct to proceed on the basis that for legal advice privilege to apply to a particular communication or document, the proponent of the privilege must show that the dominant purpose of that communication or document was to obtain or give legal advice. And so you've got to be very wary, and this is particularly acute, I think, for you in-house, about single emails which seek from multiple recipients, both non-legal and legal input and advice and that sort of thing. Now, the court is, of course, alive to the sort of broad nature of how you seek and give legal advice. So they're not sort of too purist, saying, well, that paragraph is a legal advice seeking paragraph, that paragraph isn't, let's sort of compare the length, what's the dominant purpose. It's not that crude, but you do have to be wary about it. And the court referred specifically to that in that case. So that's an area for you to be careful of. I mean, it's a regular thing in litigation. If, for example, you've got board minutes which deal with a whole host of things, and then there's, you know, heading number 5, legal update, and that's in the middle there. What you do is you'll disclose the minutes and you'll just redact out that paragraph, and that's a standard thing to do. But if it's all sort of mixed up in one, you do just have to be careful if you're mixing things, and that's probably much more acute for you as in-house counsel than it is for us advising external clients. And if we go on to the next slide, I'm just keeping an eye on time. I'll be brief on this. Well, who is the lawyer for privileged purposes? That's generally pretty obvious. It's who you'd expect. Covers lawyers' employees so long as they're properly supervised. Less clear about lawyers without practicing certificates, and it may depend on in what circumstances they don't have a practicing certificate, and if they've been struck off and so on. You could often say privilege doesn't apply. I've had that with someone where a struck off lawyer was advising a litigant on the other side, and we argued that they had to disclose their file, and we succeeded. In fact, the fact that only 2 pieces of paper were then disclosed was, there you are. The sort of lawyer who gets struck off might not be the sort of lawyer who is fully adheres to his or her duty of to assist the clients with disclosure. And we also, so it's just lawyers, and hard luck accountants, try as you might, privilege doesn't apply there, and that's become clear, even if the accountant, as say tax accountants often are giving legal advice. It's just a legal privilege. Privilege belongs to the client. Well, who then is the client? And that's the Three Rivers decision you'll all have heard of, and we need to go into the facts of that, but what the court decided there, and this remains good law, is that with a big organization, the client is not everyone within that organization, because a company, say, it's a separate entity, a separate legal personality, but it can only act via agents, whether those are directors, officers, employees, third-party contractors, or whatever. And so the court held there it's only the small unit of people who were tasked with communicating with the lawyers who constituted the client for those particular purposes. And that's been doubted in some cases, but it remains the law. It remains the case for litigation as well. The case law has confirmed that. So how do you deal with that? And there are sort of 2 broad options or schools of thought. One, at the start of a major transaction that doesn't involve litigation, define then who is charged with seeking the legal advice and make sure they are the client, and then just keep everything very tightly controlled. Or address the issue of who was the client when it comes to any dispute about privilege in due course. And often it's hard to define the client, but in the circumstances of the particular transaction, you know it when you see it. It's clear who is the client for the purposes of instructing the lawyer. All I can say really is the bigger and more sensitive the transaction or project, the more care and the more thought that's needed. You can't just say every employee of our company or organization is the client for these purposes. That won't work. And you can't just say, well, channel everything via me as the in-house lawyer. That won't often work, because often other employees or agents will need to go directly to the lawyers or whoever. That's just the way it has to work. If it comes to litigation, of course, if you have an arguable right to privilege, even if it's not free from doubt, from a litigation point of view, the starting point is, well, we'll assert the privilege and leave it to someone else to challenge. I know at least a recording was done of an earlier version of this talk a couple of years ago, because a sort of barrack room lawyer on the other side try to hurl back at me my words in a webinar like this, say, oh, you said in this seminar, Mr. Pedley, that you just assert privilege come what may and leave it to us to challenge, and that's completely improper. For the benefit particularly of anyone watching this on recording, I didn't say that then, and I'm not saying that now. If you have an arguable right to privilege, it's perfectly legitimate to assert it and let the other party challenge. If you don't have an arguable right to privilege, though, it is not proper to assert it. And I'm not suggesting otherwise, nor have I ever done so. Thank you. Right. Disclaimer over. So just a general tip for you, try and separate out the kind of business advice bit of what you do and the legal advice bit. Separate it as much as possible. Keep the headings clear. It's not the be all and end all, but all those sorts of practical things, they can be a bit of a bore, but it really does help in, should a dispute ever arise, to making sure that privilege applies, and get yourself copied in to as much as you can, because it's far, far easier to say something is privileged if the in-house lawyer is copied in and is part of that continuum of communication, because you just say it's all part of getting advice from the in-house lawyer and from the in-house lawyer to the external lawyers. Not a perfect answer, but that helps. Looking at the time, well, we've got an example scenario coming up next, but I think we'll skip past that actually. So Kate, if you can scoot on to the next slide, and I'll let Rachel address you on litigation privilege.
Thanks very much, Simon. Hi everyone, so I'm just going to run through very quickly the main requirements for litigation privilege. As you can see on the slide there, needs to be a communication between a lawyer and a client, or between either of them and a third party, or a document created by or on behalf of the client or the client's lawyers. Second, needs to be made for the dominant purpose of litigation. Third, related to litigation which is pending, reasonably contemplated or existing. And finally, it needs to be confidential. So let's just unpack those requirements a little bit. That communication, you can see there right away that in terms of the types of communications that litigation privilege might cover, you've got a significantly broader category, because now, other than lawyers and clients, you're also including third parties. And that can significantly broaden the range of documents that might be covered by privilege, but it's then restricted again by the two key questions, which are, was this for the dominant purpose of litigation, and what is litigation, and when is it pending or reasonably contemplated? And though both of those questions are very much fact specific, but taking the second one first, slightly out of order, what is meant by litigation? Well, quite obviously that would cover high court, county court proceedings, employment tribunals, arbitration under English procedural law. But what's less clear is in relation to other tribunals, public inquiries or statutory investigations, for example, under the Companies Act. And that's because the litigation needs to be adversarial rather than inquisitorial. And so that can create real difficulties in the investigations context, which I'll come on to talk about in a bit. That requirement, therefore, that litigation be reasonably pending or contemplated. Here you're really looking at whether there's a real prospect of litigation ensuing. There doesn't have to be a likelihood of a 50% chance or anything like that. It's just a question of how much in contemplation is litigation at the point of the communication being made. And then that dominant purpose must be for the dominant purpose of the litigation. Just a note on that, that's a test of dominance. It's not a test of exclusivity. And very regularly, you're going to have documents created for multiple purposes. Provided the dominant purpose is litigation, then it will be covered by privilege. And the court is likely to look at that question objectively, considering, for example, statements within the document or around the document that it was prepared to enable a lawyer to advise, and the evidence put to the court on the purpose of the document, that being contemplated or existing litigation. In terms of just a bit of a note on the side, litigation privilege will also cover communications where a party is discussing whether or not to settle litigation, but the communications have to be about settling the litigation or contemplated litigation and not just general commercial discussions. And that came out of a case involving West Ham United's move to the Olympic Stadium in 2018. Just a quick note. Simon talked briefly about the purpose of the clients being defined in legal advice privilege. And here, obviously, you can cover communications between third parties and the clients, but just a flag, it's not going to cover all internal commercial corporate communications on the basis that, there's a client and a third party. That's predominantly for public policy reasons, that there really shouldn't be a reason why corporations should have greater protection than other parties. And so a word of warning, it is and remains very important to rein in your management and board of directors, as Simon said, and impress the importance of them, of being careful about what they put in writing and running everything past their lawyers. Just like with legal advice privilege, the document must be confidential. It's just, you can't claim privilege if it isn't. And so being careful not to disseminate those documents too widely applies equally with litigation privilege. Once the document is no longer confidential, privilege will be lost. And then just a flag there that the burden there in terms of proving privilege is on the party claiming privilege, which I think probably comes back to Simon's point earlier. You think you've got an arguable case, that's absolutely fine, but it's going to be your case to prove. So that's just a quick run through on litigation privilege. I'll pass back to Simon now.
Thanks. Rachel, just very briefly, I'll mention to let Rachel get onto her investigations, but without prejudice privilege, this is the sort of joint privilege between two parties who are genuinely trying to settle a dispute. It's a question of substance, not form. While of course it helps to say something is marked without prejudice, that doesn't mean it is. My previous firm, when I was junior, working with my head of department, on the other side was a rather excitable litigant in person suing what's now Transport for Greater Manchester, and he would regularly write letters to my boss headed "without prejudice, dear arsehole," and would then carry on and do things which weren't obvious attempts to settle the case. And my boss had great fun in responding to those letters in a suitable way. But we won't go into any more detail on that. But if you're genuinely trying to settle something, it's a very useful joint privilege between both sides, with some exceptions in some circumstances. But I think we've not really got time to do that today. But if anyone wants to chat through without prejudice privilege with me, I should be delighted to do so. And so we'll skip on past that and the example slide. And again, very, very briefly, again, common interest privilege. In some circumstances, you can keep privilege in something, even if you share it with a third party, if you have a common interest in what's being looked at. So co-defendants in a case, you can often have discussions on a common interest privilege basis, so you don't lose privilege in your sort of respective legal advice. Insurer and insured, those sorts of relationships, companies in the same group, agent and principal, you could share privilege things without losing that privilege in inappropriate circumstances. But it's not always clear if that privilege applies in any particular situation. So I just say, be obviously cautious and alert when sharing something that is privileged with other than outside that lawyer-client relationship. So back over to Rachel to talk us through investigations and the particular issues there.
Thanks, Simon. So privilege investigations, this is an area that has become increasingly under the spotlight in recent years. And the question really is, to what extent will work carried out in investigations be protected by privilege? And there's two reasons really why this is particularly important. First, if it's an external investigation and there's a regulator or authority involved, you want documents prepared to be protected by privilege. So as Simon said at the outset, you're not required to disclose them to regulators or other authorities. Secondly, both external and internal investigations often cover issues that consequently lead to litigation. And so documents prepared during those investigations can often be so very relevant and actually critical to those proceedings. So as far as possible, you want those investigations documents to be protected by privilege for that reason too. So what matters might require investigation? Well, Investigations arise in a myriad of different ways. Like, I couldn't possibly claim to cover them all here, but for example, you might have an internal investigation in relation to potential wrongdoing. It might have been a whistleblower allegation, or an internal audit issue, and a complaint from a customer, or an employee claim, or allegations. In the health and safety context, there might be an accident that requires investigation, or environmental issues that need to be considered. And you may just simply get an inquiry or a notice from a regulator or another authority. And all of those might need to lead to the need to investigate and create potentially very relevant materials. So in terms of whether they might be protected by privilege, in these contexts, you might expect, that legal advice privilege is likely to apply to communications between lawyers and clients about legal issues. But the real issue here is what happens when third parties are involved, as is so often the case in these investigations matters. And that can be witnesses, for example, clients' employees, forensics or other types of experts, or auditors. And these communications, they're not going to be protected by legal advice privilege. So the question is, when can or will litigation privilege apply in these contexts? So really just looking at that litigation privilege definition on the slide there, you can see you've got those communications involving a third party, which is helpful, but then you've got the additional tests of dominant purpose, of adversarial litigation, and reasonable contemplation. So those are the two issues that are likely to come up time and again in the investigation context. And building on what I said earlier, you can see that in terms of the question of litigation being in reasonable contemplation, it's very unlikely that litigation privilege will apply to those early stage regulatory investigations unless the regulator has set out some sort of detailed case and allegation against the company. It's unlikely that they're going to be sufficiently adversarial to satisfy that test. If regulators or authorities are simply looking to establish the facts or asking questions, you can see at that stage you're not really in that sort of litigation pending phase. I just wanted to note the rather frustrating decision of the Property Alliance Group, particularly from my perspective as a financial service regulatory lawyer, in the Property Alliance Group case in 2015, where the court really missed the opportunity to confirm whether or not an FCA investigation did constitute sufficiently adversarial litigation. I think the view across the board probably is that it is sufficiently adversarial from the commencement of a formal investigation, but caution is needed because it's not settled law. And then just to talk quickly through the leading decision on ENRC on the next slide, here we're starting to see a bit more of a lenient approach being taken. And I won't go through the facts of ENRC, but you can see, and I'll talk through it in a minute, but you can see the possible public policy reasons for encouraging that investigation of potential wrongdoing, and the decision by the court that chimes with that. So in 2018, the Court of Appeal found that a criminal investigation by the SFO was in fact adversarial litigation. And the reason for doing that in this case, which again was fact specific, was when they found that when the SFO specifically makes clear to the company a prospect of criminal prosecution and legal advisors are engaged to deal with that situation, there's clear ground for contending that criminal prosecution is in reasonable contemplation. And you can see on the slide there the quotes and where the court was coming from, particularly in the context of deferred prosecution agreements, that companies should be prepared to investigate allegations from whistleblowers or investigative journalists prior to going to a prosecutor. If they weren't to do so, the temptation might well be not to investigate at all. They also covered the very thorny issue of interview notes during investigation processes, and said that where they are prepared so as to avoid or settle litigation, they're equally capable of attracting litigation privilege. In both the civil and criminal context, legal advice given so as to head off, avoid or settle but reasonably contemplated proceedings is protected by litigation privilege. So that's investigations and whether they will constitute sufficiently adversarial litigation and whether they might be in reasonable contemplation. The dominant purpose test also creates a bit of a stumbling block in terms of what is the dominant purpose for which the document was created. And a simple way of approaching that is to ask whether the facts in the report needed to be, or the facts that are seeking to be established, whether they needed to be established, whether or not litigation ensues. If the answer is no, then there's unlikely to be privilege. I just wanted to move on to the next slide and just put some of those points into practice, because there was a case just last year on these very specific issues, and that was the state of Qatar and Bank Haviland. We're light on time, but in that case, the allegations were around a conspiracy between the defendant, Bank Haviland, several other banks that they had sought to manipulate financial markets in Qatar. And it was found that a forensic report, which was prepared as part of an internal investigation, was not protected by litigation privilege. And that was because the bank had, A, not shown that adversarial litigation was in contemplation when it was commissioned, and had not shown that the dominant purpose of preparing the report was for the use in any such adversarial litigation. In fact, the court considered the most likely dominant purpose was to respond to questions from the regulator. So just looking at the reasoning, a bit of a deep dive on the next slide into the reasoning behind those decisions, you can see that the court focused right on the outset of the investigation, and that's where all of the focus was. What happened? What was the evidence? What was going on at the outset of the investigation? Looking at the adversarial proceedings in reasonably contemplation, the judge found that although the bank did believe that it could have significant legal and regulatory consequences, something more concrete was needed in terms of contemporaneous evidence to show that adversarial litigation was in contemplation. And when looking at the internal emails that were around the time, the fact that the Luxembourg regulator had been described as friendly rather undermined the argument that adversarial litigation was in fact contemplated. And so in conclusion, the court found that there was no evidence that the bank contemplated a claim from the regulator at that early point when the report was in progress, or when the first report was first instructed. And then looking at the dominant purpose test, in fact, and this happens quite regularly, and this happened on a case that I'm working on at the moment, the bank first went to its forensic experts almost immediately when the issue arose and prior to instructing lawyers. Now, the fact that the instruction was later documented formally through the law firm with the aim of improving the prospect of claiming privilege was not sufficient. And in addition, the instructions to the bank's advisors, both the law firm and the forensics firm, there was nothing to suggest a clear litigation purpose to their work. So in conclusion, the court found that the most likely dominant purpose was to establish those facts, as is often the case in those early stages. So drawing that together, it's clearly going to be a fact specific, and you cannot change the factual reality. And as Simon said earlier, you should not seek to do that if in reality the situation is that litigation privilege clearly doesn't apply. But there are things that you can do to assist in claiming that legal privilege and that litigation privilege applies. And that's moving on to the next slide. That's where these sort of practical points come in, and you can see the 4 quadrants there. So in addition to the sort of general hints and tips that you typically give about not putting things in writing and sensitive issues and things like that, these ones are perhaps a little bit more specific to investigations work. So number one, it's crucial to control those early communications during the first few days of an investigation. And in the Qatar case, the judge went through those communications in detail to assess the status of alleged anticipated proceedings and the purpose of that report. So involve lawyers early to make sure that those communication channels are put in place as soon as possible. The second quadrant there, prepare a good solid terms of reference for the investigation. And that's a document essentially setting out the key aspects of the investigation and its structures. And that's going to include a number of different factors, actually many of which are important in the litigation context as well, but will help with privilege issues. So for example, what's the objective of the investigation? Is it for the dominant purpose of anticipated litigation? Explain what that litigation might be. That isn't going to be definitive, but it is going to help everybody to focus the mind. Identifying that client group, and as Simon said, for legal advice privilege, that's also important up front. If you're not going to be able to claim litigation privilege, and who knows, because documents are created and facts and circumstances change, you want, in some cases at least, to be able to fall back on that legal advice privilege. So think about who that client group might be. Identify reporting lines and how reporting will be conducted. And that helps to limit the loss of legal privilege in materials going forward if you've thought about it up front. Then engagement of third parties. You saw how in the Qatar case that came under scrutiny. Being really careful to make sure that the purpose of different third parties' engagements is set out in their engagement terms can help when going back to consider whether litigation privilege will apply. And then communications protocols, and that certainly is one that applies just as much in litigation as it does in investigations. You know, who should you talk to before you talk to other third parties? Dealing with the press, dealing with how information will be disseminated within the business. All of that helps to maintain privilege over materials. Thirdly, interview notes. As it was found in the ENRC case, it is possible that these can be protected by privilege. So make sure that they include views and impressions of the lawyers, and also making clear to the interviewee that you represent the company, not the individual. The interview is confidential, and that privilege belongs to the company, can be waived by it. That's essentially a form of the US Upjohn warning in the States, but it does help everybody to understand the position as the company sees it. And then finally, limited waiver of privilege. Just to cover this very briefly, this often comes up when reporting to a regulator or another authority or a third party such as an auditor. As Simon said earlier, anything said to a regulator is not going to be privileged, but regulators typically can't require the disclosure of privileged materials. So if you do want to disclose privileged advice to a regulator, and there can be very good reasons for wanting to do that, you can often seek to do it by a limited waiver of privilege, which makes clear that you're disclosing it to that third party for a strictly limited and specific purpose, which is stated clearly, on terms that the recipient will treat that information as confidential, and explicitly on the basis that you have no intention of waiving privilege in the document generally. And a bit of health warnings though. Limited waiver of privilege doesn't work in all jurisdictions, and specifically doesn't work in the US. You can only do it if the other party agrees to that approach. And in many cases, the regulators can still use their statutory powers, use that information for other statutory powers, and provide that information onwards if they wish to. So that's it on privilege and investigations. I guess the key takeaway really is it is likely to be fact specific, but there are a number of practical points that can be taken to assist prospects of claiming privilege. And many of those really do need to be taken at the outset of the investigation. And that's it. So I'll pass back to Simon.
Thank you. Well, actually tying neatly into that last quadrant on Rachel's last slide, just be very wary about other jurisdictions. Don't assume English rules apply there, whether that's privilege rules in litigation going on, say, in a foreign jurisdiction, or stuff done in the legal context in another jurisdiction relevant to litigation or whatever it might be here. Just take local advice. Don't make any assumptions that the position is the same. And privilege in the criminal context, just to say, I'm not going to talk about that because it's not my area. There are some exceptions where, as I understand it, where clients' communications with a solicitor are preparatory to an act of fraud and involved in it, then privilege can't be claimed. But let's hope none of us ever have to consider such issues in our working lives. So just onto the sort of wrap-up slide, and this is just, I guess, a general point about, okay, if you can move on to the next slide, just what happens, generally good advice, not which ties into privilege. If you can say something to someone, don't put it in writing. So if you've got something sensitive to discuss, pick up the phone to your co-director. Don't send them a WhatsApp or a text, because you are not thereby, or certainly not as straightforwardly, creating a document that has been preserved. Whether voice messages are preserved and stuff, that's a different question. If you have to put it in writing, don't put it in electronic form if you can, because they can multiply and be forwarded on, and privilege can be lost really easily, and they last forever. Electronic documents in some form, they're on some server or some cache or some backup somewhere. And if you have to put it in writing in electronic form, be really careful about who you copy it to, because privilege can be so easily lost. And while in 90% of litigation it's obvious what's privileged and what isn't, it won't be an issue. But in those big and substantial and difficult disputes, you don't want to be left having to disclose embarrassing, difficult stuff which just should never have been created in the first place. It can just look bad, even if it's not substantively that bad. You just don't want to paint a picture of how things are in your organization. So yeah, generally, if you can go back to your management and your boards and tell them to just pick up the phone to each other and don't send messages, that would be jolly helpful. So that is our brief canter through various aspects of privilege. I believe there have been some questions popping up. I see there's various questions in the Q&A box. So Lino, have you got anything you could ask us?
Yep. Thanks very much, Simon and Rachel, for that. There have been a few questions asking about privilege applying to, just extending on your point, Simon, about applying to employees who are not qualified, such as paralegals or trainees. I wonder if you could just expand on that.
Yeah, who are lawyers? I mean, so in the UK, solicitors, barristers, in-house lawyers, foreign lawyers, qualified lawyers, their advice is privileged. Also, other sort of licensed givers of advice, such as licensed conveyancers or legal executives who are properly licensed, and similarly, other people who are in a regulated position to give legal advice. So licensed conveyancers, people who are licensed to do probate services. Within that context, if you give legal advice, even if you're not a lawyer, if you're licensed and regulated, the privilege can apply in those circumstances. But yes, absolutely, it applies to employees, of course, provided they are properly supervised in accordance with the relevant regulatory requirements. So the fact that my secretary might respond to a client and forward something on, you don't lose privilege because of the fact that it goes through my secretary's hands at a silly level, or my trainee or the paralegal or whoever it is. So no, provided people are within that environment and they're properly supervised, that advice is privileged. I mean, I suppose there might be questions where if you've got a team of paralegals doing one thing and they're sort of completely standalone and they're sort of different line management reporting to where the in-house lawyer is, conceivably, even though they're giving legal advice, they might not be lawyers. And this goes back to the fact that it's just a lawyer's privilege. So there was one of the cases in the FRC and Sports Director. It was around something, a report Deloitte had prepared, and they were trying to claim this was subject to litigation privilege. But this was going back to Rachel's point. This was all the report was actually about. Well, how can we structure things so as to minimize the chance of litigation arising in the future? It wasn't in relation to a specific thing, and it was done by Deloitte. If that report had been done by lawyers, it would have been covered by legal advice privilege, but it wasn't. So you've got to be careful. But if everyone's properly supervised and the chains of communication are there, you can claim privilege. Bearing in mind, if you've got an arguable claim to privilege, you claim it. You've got to prove it, but it's for someone else to challenge it in practical terms. But yeah, your supervised employees are good.
Okay, we're pretty short of time, actually. We've got there are quite a number of other questions that we have had, and I think what we'll do is we'll follow up with those separately. I can see one that's just come through about, can WhatsApp messages also be disclosed? And the answer to that is they most definitely can be. So just because we've been talking about meeting notes and emails, disclosure obligations extend to documents in whatever form, and we are finding that people are that clients might think that things like instant messaging or WhatsApp or any of those sort of platforms are beyond the reach of disclosure. They're most definitely not. And in fact, we've been working on an exercise where key evidence actually was in the WhatsApp messages that had to be disclosed. I think if we can just move the slide on, Kate, that's probably the end of today. So what we'll do is, if you could let us know how we've done and what topics you'd like to hear more about. That's obviously very helpful for us, and then we can make sure that these sessions are more tailored to what it is that you would like us to hear from. But thank you for joining us today. We've got webinars coming up in May, so please do look out for those, and we look forward to seeing you then. Thank you very much.